Happy New Year! My name is Elliot Burton and welcome to this employment law update brought to you by Law 365. And in this video, we'll break down the key changes to employment law and look at what it means for you when we discuss what's in store for 2024. Let's jump into it. Okay, so first up, let's start with holiday pay. So as of January 1st, in order to preserve EU principles, the definition of normal pay for annual leave purposes has been clarified into UK law. So normal pay includes payments such as commission, payments related to length of service, seniority or professional qualifications, and regularly paid overtime. Additionally, there's now an express provision on carrying over holiday into the next leave year for those on long-term sick leave or family leave, such as maternity leave, paternity leave, that sort of thing. And further, employers must give workers a reasonable opportunity to take annual leave and or encourage them to do so, or warn them of the risk of losing their annual leave entitlement at the end of the holiday year. I should say that these amendments only apply to the first 4 weeks of holiday entitlement. However, for all holiday leave, part-year or irregular hours workers will now accrue holiday as they work at a rate of 12.07% of the hours they worked during the previous pay period. Now that will start from April 1st, 2024. Next up is flexible working. So exciting and long-awaited changes are anticipated in April this year. Now, so requesting flexible working, i.e. requesting changes to days, to hours, to places of work, shall become a day one right. So employees will be able to make these requests twice in a 12-month period. Now, employers can reject these changes for specific statutory grounds, although they will be obligated to consult with employees before rejecting a request made for flexible working. It's important to note that this is still a right to request flexible working and not an absolute right to work flexibly. Next up, we have family leave protection from redundancy. So, changes are expected to come into force on April 6th this year, enhancing the protection for those on family leave, i.e. maternity, paternity, adoption leave, shared parental leave. The protection relates to the existing entitlement to be offered a suitable alternative vacancy in the case of a redundancy situation. So, for pregnant employees and those on maternity leave, the protection period will now be from the moment the employee tells their employer about their pregnancy right through to 18 months after the birth of their child. For employees on adoption leave, the protection shall be from the date of placement and also last for 18 months. And for those parents who are on shared parental leave lasting longer than 6 weeks, but who've not also taken maternity or adoption leave, the protection period shall last for 18 months from the date of birth or placement. And just a point to clarify, this protection is not a full redundancy immunity, and those on family leave may still be made redundant if there is no suitable vacancy. So next up, we have sexual harassment in the workplace. So we're now looking ahead to October 2024, and employers will be required to take reasonable steps to prevent sexual harassment in the workplace. Now, breaching this duty could lead to a 25% uplift in any relevant tribunal awards. Next one up is predictable working patterns. So this is expected to come into force around September 2024. Workers whose hours lacked predictability with at least 6 months service can request predictable working hours, and employers will have a month to respond. So, like flexible working, employers will have the option to refuse these requests, and employees will be able to make 2 of these requests in the 12-month period. Now, this right is targeted at 0 hours and atypical workers, but it will also cover workers who lack predictability about their hours. Next up, we have carers leave. So, Carers leave shall be coming into effect this year. Now, starting from April 6th, employees will have a day one right to take up to a week's unpaid leave in any given 12-month period to provide or arrange care for a dependent with a long-term care need. Next one up, we have TUPE. So for small businesses, that's businesses of up to 50 employees, or where there's a TUPE situation where only 10 people are transferring, regardless of the overall size of the company, informing and consulting on TUPE transfers will become much easier. So if the TUPE regulations, these new TUPE regulations apply to you, employers fitting this criteria can now directly consult with staff. Now this bypasses the obligation for the employees to elect representatives and only consult and inform the employee representatives. That will be done away for small businesses and those businesses with only 10 people transferring. Next one up, and final one, is the failure to prevent fraud regulations that are coming in. So finally, for large organizations, regulations are expected to come in this year with a new corporate offense for failure to prevent fraud. If it does come in, this will mean updating internal policies and updating staff on training regimes. So all in all, there are many changes that are coming in this year that employers need to be aware of. Law 365 will be keeping you informed of the changes as they progress. So thank you so much for taking the time to watch this video, and as always, if you have any thoughts, surprises, questions, delights, please get in touch. Happy New Year.